Good morning and a very warm welcome to everybody. Thank you so much for joining us for what promises to be hopefully an extremely enlightening and interesting discussion. I'm Jocelyn Katz and I head up the competition practice at ENS Africa. I will be facilitating the discussion today. And what we are talking about is the intersection between competition law and data protection laws, particularly in relation to digital markets. And maybe not so much the intersection, but how they may bump up against one another, which we'll hear about in a moment. So, as you know, POPIA has commenced, but enforcement will be starting this year, 1 July, after the grace period expires. We have also seen a significant increase in focus on digital markets globally from a competition perspective. Now, data plays a very big role in digital markets from a competition law perspective, but the use of it is also regulated by data protection laws. As such, we'll cover various topics on the role of data from a competition law perspective and how data protection laws can act as a constraint on the exercise of competition laws. So very briefly, the format of today's discussion will be a Q&A with four main topics, so to speak. We'll then follow that with some concluding remarks and questions if we have time. So if you have a question, please do go ahead and type it into the Q&A box at the bottom of your screen. We will do our best to get to answer your questions, but if we don't manage, please feel free to leave your name and email, and we'll try our best to send you an email afterwards. There is a fair amount of ground to cover, so I'm not going to delay. Our four topics will be competition in the digital economy, the role of big data in digital markets, the role of data and data protection laws in merger control, and how data can facilitate collusion. So our lineup for today, from the competition team, we have Natalia Lopes. She is one of the directors in the team. She has 20 years of experience in all aspects of competition law, and she will provide her very deep insights into the various competition issues as they relate to data protection. We also have Jeremy De Beer, who is a candidate attorney in the team. He has a burning passion for this particular topic, so he has lots of interesting things to share with us today. On the data protection team, we have Ira Gunning. She's a director in our banking and finance department. She's also our resident POPIA expert, and she specializes in all things data protection and consumer-related issues. We also have Nicole Gabrick, who is a director in our disputes resolution department, who, among many other things, deals with breaches and disputes relating to data protection. So with that very brief introduction, I think let us kick off with some context under our first topic. So the first question is for Jeremy. So Jeremy, let's start with sort of what is the background to all of this? Isn't competition law as we have it already sufficiently developed to deal with issues raised by the digital economy?
Thanks, Joss. So that really is the question that regulators all over the world are asking themselves at the moment. We've seen a massive increase in the focus on antitrust enforcement, particularly a crackdown on big tech and big data, really all around the world. It's happening in the US, in the EU, in Australia. And the focus has really been on Google, Apple, Amazon, and Facebook. And although the complaints that are against them are not identical, one of the common themes is how they collect their users' data and what they do with that data. And that's essentially where the scrutiny is coming in now. So we need to ask ourselves, is competition law sufficiently developed, or do we need to actually bring in new regulations, new tools, some amendments to actually cater for these things? There's a saying that society advances, but the law only catches up 20 years later. And I think that's the position that regulators are finding themselves in now, that our society has advanced to a point where our laws are essentially playing catch up. And so that's really where the focus has become now.
And just a follow-up question. So what exactly is the relationship between data protection laws and competition law?
So the relationship is, the focal point between the two is essentially consumer welfare and consumer protection. They serve similar but different goals in that sense. But where the constituent elements of both data protection law and competition law are met, then their application to a given scenario remains appropriate. But the problem with that is that you then risk having differing results when a matter is assessed by different regulators under different laws. So there's a need for collaboration between your information regulators and your competition authorities. And this is something that the Competition Commission of South Africa has recently noted in its digital economy paper, which was published for public comment. It's not final yet, but they do actually note the need for collaboration with the information regulator in particular. And the Competition Act and the Protection of Personal Information Act already cater for this. So in Section 82, it provides that where there is concurrent jurisdiction, the Competition Commission must actually enter into an agreement with that other regulator. And the same under POPIA, it needs to refer it to the appropriate authority where it considers that a matter relates wholly or partially to that authority's jurisdiction. So we really need to actually have this collaboration to avoid turf wars, because at the end of the day, both sets of laws are aimed at protecting consumers.
Right. So speaking then of collaboration, let's turn to ERA for some POPIA perspective. What is technology's impact on consumers and competition?
Yes, Jocelyn, that's very interesting because we're living in a world where our consumers are becoming very privacy savvy, and they now know that they've got privacy rights. And we recently saw it with a big exodus from WhatsApp. And because people heard WhatsApp was going to share their personal information with Facebook, they started leaving the platform, and we saw them moving towards the likes of Signal and Telegram. And what I found quite interesting is if you go and read the privacy policies on the websites of Signal and Telegram, you'll find something very interesting. Telegram makes it very clear that it too can share personal information with its holding company and with another company in the group located in Dubai to improve their services. If you look at the privacy policy of Signal, it makes it clear that it can amend its privacy terms, and it just needs to publish an amended set of terms. And by continuing use of the platform, you agree to those amended terms. So they could monetize the data going forward, maybe perhaps in future. So I think gone are the days of us assuming that we can just put anything in a privacy policy and people are going to click and accept. Sometimes they do, but sometimes we now find that these companies can compete on what is included in their privacy terms, such as data sharing.
Thanks, Erin. I think Jeremy might have something to add to this point.
I do, yes. So ERA actually raises an interesting point there and to actually foreground our discussion moving forward, we need to distinguish between where competition, or rather data protection, acts as an internal influence on competition law and where it acts as an external influence. So what ERA was referring to is where data would act as an internal influence. That is where there is competition on the levels of data collected and the level of data protection provided. And the authorities are already quite well equipped to deal with those. They're sort of more conventional violations. So for instance, your standard cartel conduct, where two competitors agree, okay, well, we are not going to share these forms of data, or we are not going to compete with each other on the levels of data protection provided, which, as Era noted in the example of WhatsApp, Telegram, and Signal, is something that is quite important. On the other hand, though, data can act as an external influence on competition law, specifically data protection laws, and that is where it could impose binding limits on the exercise of competition laws. So for instance, where data protection laws may prevent a competition authority from imposing a remedy or accepting a commitment that it would otherwise consider desirable. So for instance, a big tech firm with access to lots of data as a gatekeeper platform, it might be desirable to say, make this data available to your competitors. Let's lower barriers to entry, share this data. And we need to then ask ourselves, does data protection law allow this?
So I think that is, in fact, a topic we are going to return to in a moment, because I think that raises a very interesting point. But in the meantime, perhaps I can put to Nicole a question about what the implications of big data are for data breaches, just coming back to the point Era was talking about earlier.
So we've seen, as Era mentioned, what's happened with WhatsApp and the ramifications of updating privacy policies. But where companies hold big data sets, we've seen the likelihood of security compromises or breaches being quite detrimental to industries and share prices. A recent example in South Africa was when we had the Experian incident towards the end of last year, where 24 million South Africans' ID numbers and I think 800,000 companies' details were inadvertently leaked. And try as you may, after the fact, it's very hard to contain those breaches. That information ended up in a server in Switzerland. And what we've seen is we've had to now adapt our ID numbers to provide a safer platform. And Home Affairs has actually come out to say that they're changing ID numbers or looking at changing ID numbers to be a more secure set of data. It may not be because of the Experian breach. It may be just because they want to produce safer numbers. But what we do see is when mass data sets are lost, it can be massively detrimental to large numbers of people.
Thanks, Nicole. I mean, I think that brings us quite neatly to our next topic, which is the role of big data in digital markets. And I think we're going to look at things like abuses of dominance. But maybe as an opening question for that, I can ask Ira, we're throwing around the term big data, but perhaps you can tell us what is big data and when will it be governed under POPIA?
Absolutely, Jocelyn. Now, first of all, as far as big data is concerned, I'm not about to give you any technical definition, but what is big data? It is enormous, huge amounts of data. It's so big that our traditional data management tools just cannot cope with it. It cannot process it. So we break it into little chunks of data and we process it on distributed networks so that each network processes a little bit of that data. So it goes hand in hand with sometimes called the 3 V's and sometimes called the 5 V's. So the V's refer to volume. It's enormous, enormous amounts of data. The second V is variety. We're dealing with structured and unstructured data. We're dealing with spreadsheets. We're dealing with databases. But we're also dealing with data incorporated in recordings or photos, chats, and so on. So that is your variety element. Velocity refers to the fact that this data is growing exponentially. Look at our COVID-19 stats. It's just growing all the time. And then next is variability. So that is the inconsistency of that data. Can we rely on it? How reliable the data is? And lastly, people add value to it, because if we can manage that data, if we can process that data, then there is huge amounts of practical value that we can learn from that data, because we can analyze behavior, we can predict behavior. So when does this fall to be regulated in terms of POPIA? So whenever you have personal information that forms part of this big data, and it's being entered into a record and processed in South Africa, that will kickstart the application of POPI. So just as a practical example, which I find very interesting, is big data analytics is being used to develop a COVID-19 mortality risk calculator. So this calculator is going to use big data to analyze gender, behavior, socio-demographic features, underlying conditions. And that would be able to tell us how likely you are to catch the disease, how likely you are to succumb to the disease, and then to give us indications as to who should get the vaccine first. So enormous amounts of practical application of big data if we can get to grips with it and if we can process those large chunks of data. Likewise, in the competition market, it can be used to create algorithms to predict consumer behavior and so on.
Well, that brings me quite neatly to my next question for Jeremy in the competition space. So, what is the big deal in competition? Why is data and access to data a growing concern for competition authorities, as you mentioned, not just here in SA, but worldwide?
So I think the reason is because competition authorities, as I said, are still playing catch up, and we're only really starting to realize the effects of big data now, particularly on market power. So we've got our very traditional understanding of market power, which is very closely tied to market share. So we know there are various thresholds set out in the Competition Act for determining whether a firm has market power, but those don't currently take into account data as a competitive parameter. So we need to actually look at what kind of competitive advantages can big data and using data analytics to analyze consumers, give them various targeted offerings. What effects are these having on competition? And I think it's generally accepted that the big tech firms do have a massive competitive advantage, almost insurmountable compared to their much smaller competitors. But a lot of this hasn't been taken into account because data hasn't been taken into account as an element of market power. So I think there's probably a need to focus more on some other factors, various key inputs such as data, barriers to entry, the degree of innovation, economies of scale, all of those kind of things. And these are things that are not currently taken into account when we assess market power. And once you've established that a firm has market power, and we know that they've got access to these vast caches of data, which give them these huge competitive advantages, you could see why it would be desirable from a competition perspective to say, all right, well, these barriers to entry are far too high. We need you to actually share your data with your competitors so that we can actually promote competition in this market. But again, we need to ask ourselves the external influence question: does data protection law allow this?
Yes, indeed. So I suppose this is one of the instances of the sort of bumping up against one another that I was talking about earlier. And the question, I suppose, I'm not sure, Era or Jeremy, whether you want to answer this particular, or at least the first half of this question: can access to data be ordered under the sort of essential facilities doctrine in the Competition Act to reduce those barriers to entry that you were talking about? And if so, how does that, sort of happen under POPIA? Would POPIA allow the sharing of that data? And are there any limitations from a data protection perspective? Nicole, perhaps this is a question for you from a limitations perspective.
So let me jump in there, Jocelyn, and thank you for that question. I think that we've certainly seen examples of this in European jurisdictions, where competition authorities, particularly in France, there's been a tested case, have ordered certain companies to share information in the context of anti-competitive behavior, particularly market dominance cases. It automatically raises a defense to say, no, but because of data protection reasons, we can't share this data. It would be contrary to GDPR, for example, in Europe. What I believe will be the instance here is you have to comply with certain orders. And so you would fall foul of not complying with law or legislation if you didn't comply with a competition tribunal order per se. But that doesn't mean that you can hand over data and that's the end of it. Your other parameters within POPI would have to come into play. You still have to consider your data minimization principles, your security safeguards. What they ordered, for example, in France was that the data subjects had to be notified of the data sharing and be given the option to opt out of that sharing. So you can't just share the data and that's the end of the story. Era, do you agree with me?
Just trying to unmute myself first. Yes, Nicole, absolutely. I think what makes POPI a very special statute is that you can never just say, yes, this is fine in terms of POPI. You need to unpack all 8 conditions. You need to check whether you are using red flag data, that is special personal information such as health information. Will that be shared? Will it not? Are you going to do a trans-border transfer of personal information? So absolutely, holistically, you would have to comply with the entire act.
And just to add to that, Era, I think we're going to start seeing this in normal court litigation process, in arbitrations process as well. How do you utilize data in complying with orders, in getting to where you need to be in terms of evidence? And we're going to see a weaponization of data in various spaces.
I can't agree with you more, Nicole. We're going to have to wait to see how it all unfolds.
I think that's absolutely right. And I suspect we'll probably get into some of this in the context of mergers as well when we get there. But I'm wondering, Natalia, if you want to give us a little bit of insight into this tension between what the competition authorities or any other court may order as against, what Nicole and Era have just described from a POPIA perspective. And I'm thinking more along the lines of, it's all very well de-identifying the data or seeking permission, etc., in whatever way it does. But what if that doesn't quite meet the need or solve for the harm that the competition authorities are trying to solve for? That's the difficulty I think that we're going to see play out both in the competition space and all other courts. Nat, I don't know if you have any thoughts on that.
Yeah, sure, Jocelyn. I mean, I completely agree. And in our space, effectively, the tribunal and the Competition Appeal Court should only be ordering a remedy which addresses a competitive harm or a public interest harm that has been identified. And so we would argue that to the extent that the order in question does not address that particular issue, then it wouldn't be a competent order. And so we need to very carefully consider in the competition space whether the ordering of granting access to data is in fact absolutely necessary in order to address the competitive harm, or it may result in greater harm and come clashing up against the PAPIA legislation if it's not considered very carefully. So I think that's something that the competition authorities are going to grapple with going forward, now that they've identified in their draft paper on the digital economy all of the various very difficult issues which they are grappling with and how to deal with them.
Yes, okay. Fun times ahead for all of us in that sense. So perhaps, Jeremy, I can return to you just to articulate for us what kind of harms are posed by the abuses of this kind of data or market power in the digital economy. And, is there a need to rethink our existing theories of harm, so to speak?
So in the context of an abuse of dominance, I think the question that we need to ask ourselves is, what are these firms doing with our data and how are they doing it? We've seen an increased focus on algorithms and AI, where firms have essentially built digital profiles on all of their consumers based on the data that they have collected. And they can use the insights that this data confers to do a whole host of things. One of the main ones that's being looked at quite intensively is personalized pricing, as well as self-preferencing. So self-preferencing is a particular danger in vertically integrated firms, and that would be where a platform benefits from both owning the platform, but also competing with sellers on it. So an example would be something like Amazon, where they own the platform, but they also sell their own goods there. So they could preference their goods by, making sure that search results display Amazon products first. And that clearly has anti-competitive effects. Personalized pricing is a bit trickier. I wouldn't say that it's per se a problem, because it can essentially be good for consumers as well. You could get a lower price if they say, okay, well, based on the data profile that we have built, we know that Jeremy is prepared to pay this price, so we'll give him a slightly lower price. But it might also be quite harmful to consumers, because they know, okay, well, I know from the websites he visits and where he's traveled and all of those kind of places that he's maybe quite affluent and would be prepared to pay a higher price. So those are some of the more novel forms of harm that are being looked at. And to that extent, there is a need to develop those theories of harm further. But even on the more conventional theories of harm, we still need to actually determine the anti-competitive effects, and proving those anti-competitive effects can be quite technical and quite tricky. So something that the Competition Commission has noted in its digital economy paper is the need to rely on expertise. And I think it even mentions that it may liaise with international regulators, because as we know, data is not necessarily confined to a national or a geographic market in the same way as, a conventional sort of retail market or something like that. So the need for collaboration and the need to rely on expertise to prove those anti-competitive effects is definitely something that the Commission will need to look into.
Yeah, indeed. And Nicole, maybe just apart from the competition space, what other harms are posed by big data in the digital economy? What are the dangers of the sort of mass collection of data, excessive collection of data from a data protection perspective?
So I think it's very important to look at the negative or potential negative impacts on the data subjects themselves. Ira mentioned earlier about automated decision-making and profiling that happens through the collection of data through some algorithms that are applied. And what we've seen happen is errors or bias in collected data or shared data that come into automated decision-making processes. So this can mean we've got incorrect classifications of data, inherent bias in the way in which we classify data, and those can have very serious knock-on effects to the data subjects. We've recently seen some safeguards and guidelines that have been recommended by the European Data Protection Board. So they're looking at recommendations that companies should be doing that process big data. We need to look at regular quality assurance checks of your systems to make sure that your data subjects are being treated fairly and not discriminated against. We need to do algorithmic auditing to test our algorithms to make sure they make sense. What about contractual assurances for third-party algorithms for your data subjects to make sure that there's fair application of algorithms? So these are all just sorts of things to think about. It's not just what is the anti-competitive structure for perhaps the companies involved in it, but the actual effect on your data subject who can be negatively impacted.
That is so. I'm wondering if, in the interest of time, I know that there's quite a lot to talk about on this dominance, or the nature of these dominance questions, but I do want to change tack a little bit to make sure we cover all of the topics. So I think I'm going to move on to the role of data and data protection laws in merger control, in the context of mergers, because it's also not only in the dominance space, but about firms that are merging, essentially, and they bring their respective data sets together. So Natalia, maybe a question for you on this. What difficulties do the competition authorities face when assessing mergers and acquisitions in the digital economy, and particularly in relation to this sort of data question?
Thanks, Joss. I'll try and restrain myself in my response, because one can really speak for hours on this topic. And the Commission, in its draft paper on the digital economy, has identified various issues which it is coming up against. So the starting point is, when there is a merger, the Commission needs to be able to meet 3 requirements in order for it to be notifiable to it. So it has to meet the jurisdictional requirements. It needs to be a merger as defined in Section 12 of the Competition Act. And lastly, it needs to meet the specified merger thresholds. And so I think the Commission is coming up against difficulties in 2 of those respects, the one being the issue of jurisdiction, and the other being the issue of merger thresholds. So by way of example, insofar as and we spoke about the Facebook WhatsApp merger and the issues that people had with that, given the sharing of data between the two, because WhatsApp has no revenue in South Africa, it didn't meet the merger thresholds. And so it wasn't notifiable within South Africa in order to give the South African competition authorities an opportunity to consider its impact on the public as a whole. And so there is an ability to deal with that in terms of the Act, because in terms of a relevant section, a small merger, namely one that doesn't hit the thresholds, can be called on to be notified within a period of 6 months from the date of implementation. But the issue is that those sorts of transactions may fall under the radar, where the Commission isn't aware of it until after the six-month period passes, and then it has absolutely no jurisdiction in order to be able to do anything about it. And so an issue which they're encountering is, how do you value the asset value attributable to a WhatsApp in South Africa? They're grappling with, how does one assess those merger thresholds where it can assume jurisdiction over that particular merger? And there are a lot of issues that by way of example relate to that. So in the whole Google Fitbit merger, the competition authorities did manage to timeously get on top of that issue, and it was a small merger, but they managed to get the parties to notify the transaction in South Africa. And I mean, that was quite an interesting merger, because really at first blush, Google and Fitbit doesn't appear to immediately raise concerns. They seem to be in quite disparate markets, and therefore there would likely not appear to be an issue. But the issue that the competition authorities have with these sorts of issues are what they term as killer acquisitions. And so that's where a large, big tech company, such as a Google, such as an Amazon, will acquire a little competitor, or it will acquire an entity in a seemingly unrelated market, but which it can use to access data to advantage itself downstream and to advantage itself in other related markets in which it operates. And so here an issue which was identified is that Google is substantial in the operating of the Android operating system, which wearable fitness device manufacturers need access to connect to your smartphone. And so there was a concern that by virtue of this, they wouldn't have access to that operating system. There were a variety of other issues by way of example, insofar as access to data is concerned. They were concerned that Google could use this data for an unrelated purpose and then advantage itself in other particular markets. And lastly, there was also a concern that current users of Fitbit data would not get access to it. And so in that matter, it was a multi-jurisdictional matter notified across numerous jurisdictions. And so there, I believe that the remedies were very much aligned between the competition authorities and that the South African competition authorities did go and consider what the internationals were doing. And so the remedies in South Africa were very aligned, and they were quite interesting and novel remedies. So by way of example, Google was not allowed to discriminate because of the vertical issue between Fitbit and other competitors to Fitbit in the provision of the operating system and various other issues. So there was the imposition of non-discriminatory treatment between downstream competitors in Fitbit. There was also an order of access to data by previous users of Fitbit data, but subject to not charging by Google, and secondly, subject to the user's consent. So it does seem that the competition tribunal is considering the issues of the particular underlying user's personal information and not simply willy-nilly ordering access to data without considering the impact on the personal issues. And so it's interesting because this was all ordered within the existing framework of what we currently have in competition legislation. And so that does bring about the question of whether it's necessary to embark on further changes to legislation to deal with the digital economy, or whether what we currently have does actually suffice in order to deal with these particular types of issues.
Thanks. I mean, just an interesting observation for me around killer acquisitions is the data sharing point is obviously, or the access to data point is very important and very relevant. But the concern is also, I suppose, particularly where it's small mergers and it's not caught, so to speak, by the net, that it really ends up stifling innovation, right? Because a number of these startups start developing their products, start developing their ideas with a view to being bought out by one of these very large big data firms. And has the Commission addressed that at all in its paper? And you know, do you think that's something they should be addressing outside of the toolkit that they already have?
So, I mean, it's such an interesting issue because it hasn't been dealt with by the Commission. There seems to almost be an assumption that it's very easy to identify which startup is going to be a competitive threat to an Amazon or a Google. And that's certainly not the case. I mean, insofar as various different types of literature are concerned, more often than not, they fail. Most startups fail. It's very few and very seldom does one have a unicorn. And the Commission almost seemed to assume that every startup that's being acquired by an Amazon or Google is readily identifiable as that unicorn, which is not the case. And you are absolutely right. The Commission, I think, must carefully consider and balance the issue of regulating in order to ensure that there is no harm to consumer welfare, in order to ensure that there is a dynamic competitive process that's put in place, but without effectively stemming the innovation that you have by these startups, by effectively over-regulating the market. There's so much fantastic and fabulous stuff out there that's going on right now with these startups, and the Commission must carefully walk that line so as not to lose the fantastic innovation that we're seeing out there.
Completely agreed. So just in the merger space, I'm going to turn to ERA now. So in the context of a merger, when two firms with significant personal data on their users merged, in the context of a merger, how is the sharing of data through an acquisition permissible under POPIA? How does that work under POPIA?
Yes, Jocelyn, that's very interesting. And again, with POPI, we can't just say it's one thing that you need to consider. You have to consider all 8 conditions of lawful processing. But the starting point is, when are we dealing with personal information? So if it's just data sharing in general, POPI might not apply. But the minute you hit personal information or personal data, that is where POPI kicks in. So personal information is any information relating to an identifiable human being or juristic person, such as a company. Now, this is very interesting because we are based on the EU Directive on Data Protection, which came out in 1995. It was replaced by the GDPR about 2-3 years ago. And there they only recognize human being data, human being personal information. In South Africa, we recognize juristic person information. So very interesting for cross-border mergers or acquisitions. So here we've got this element that juristic person and personal information of human beings, if it relates to identifiable people, would be falls perfectly within the ambit of POPI. So where you see it is in the ambit of POPI, you need a lawful justification for processing that information. So you could argue it's in your legitimate interest. You may have consent in your T's and C's and the like. But where we normally see a stumble block is the further processing of that information. Is that sharing of information compatible with the reason why you collected that information in the first place? We also find that sharing of information must be done in a secure way. You must be accountable. Data subjects have got rights to be notified of the sharing and so on. So quite a few things that we need to take into consideration. Again, we need to take into consideration whether we're dealing with ordinary personal information such as names and contact details, or are we dealing with special personal information such as race information or health information, because then stricter conditions apply? Are we dealing with a trans-border transfer of personal information? Now, what I find very useful in the South African context is when we try and understand the application of POPI, is to look at the guidance that has already been issued in foreign jurisdictions under the old EU directive, or in terms of the GDPR, or under the Data Protection Act in the UK. And when I write legal opinions, generally, my first stop is to go to the Information Commissioner's Office, the ICO in the UK, the equivalent to our information regulator, to stop at her website and to see whether she has considered this area before. And if you simply do a Google on ICO, checklist, acquisitions, mergers, data sharing, you would find a very, very valuable checklist that can be used for due diligence purposes. So it is incredibly, incredibly important in a merger and acquisition to take, in the due diligence, to take personal information into consideration, and then to remember that juristic person element that we deal with in South Africa.
Yeah, it certainly is a challenge from a cross-border perspective. Nats, perhaps you can tell us, sort of what the solutions to these on a practical level may have been. Have we seen any conditions in mergers dealing with this stuff?
Sure. So, the Commission, I think, put out its draft digital paper because it doesn't have all the answers, and it thinks that there may be some gaps in its guiding legislation that it may need to supplement in order to deal with these issues. So interestingly, I think that the Act does cover a lot of the difficulties. So by way of example, Naspers was looking to acquire We Buy Cars. And so Naspers is a owner of Auto Trader, obviously where everybody puts their cars up for sale. It's also the owner of OLX, where private persons may advertise in order to put up their cars. And it was looking to buy We Buy Cars, which is in the guaranteed purchase of car space. And so whilst at first blush there doesn't appear to be any issue, the issue of data came in again. And so what the competition authorities found was that Naspers obtains a huge amount of data from Auto Trader, where effectively you have your various retail dealerships putting up cars for sale and pricing for sale, and therefore it was getting in huge amounts of big data. In OLX, on the other hand, it was getting information as regards private sellers that were putting up their cars, and that all of this information could be utilized in the guaranteed car purchase space by We Buy Cars in order to create network effects, basically, and cause We Buy Cars to almost have an incontestable position in the market that its competitors could certainly not deal with. And so with the current tools that the Commission and the Tribunal currently have, they decided to prohibit the deal because their view was that the network effects that would arise from this merger would make We Buy Cars unchallengeable within the market in which it operates. Certainly, I mean, the Commission, I think, acknowledges that and that it's becoming more savvy in dealing with these particular issues, but it does identify that there are issues with the merger thresholds. And so it wants to issue guidelines. Nothing has been specified as yet, but it's a desire to issue guidelines in order to deal with how to assess merger thresholds in these sort of data, a digital type of acquisitions, and also guidelines on how to assess merger creep, mandatory filing requirements where you're a particularly dominant identified tech firm, then they would require mandatory requirements, and a whole range of other potential solutions which it's looking at. But there I caution once more that the Commission must be very mindful not to stifle innovation with over-regulation, and the Commission must also be very mindful not to overstep its bounds. The Commission is a creature of statute, and it is required to act within the four corners of the Competition Act, as well as any regulations issued in terms of the Act. And so it cannot issue a guide note beyond the ambit of that which is currently legislated for. And if that is what it is looking at, then it may need to consider approaching legislators in order to change the manner in which mergers are assessed in order to widen its net. It cannot do so unilaterally.
So potentially, if this problem grows, we may be facing a further amendment to the Competition Act at a point, but who knows at this stage. So Ira, just a final question for you in the context of mergers before we move on to the collusion stuff. From a data protection perspective, what are the sort of considerations that are important here in the M&A space?
Well, first of all, like I mentioned, it's very important to do a due diligence on the target, Jocelyn. And we saw a very interesting case with the Marriott and Starwood Hotels case recently. So Marriott acquired Starwood Hotels, and in 2014 there was a huge data breach, and personal records of 339 million people were compromised, and they only picked it up in about November 2018. And in that case, the ICO fined Marriott £18.4 million. And it specifically said you should have done a better due diligence on Starwood and their security measures around their database before you acquired them. So I think certainly for take-home point is that we must focus on a proper due diligence before a merger or an acquisition, and we must take into consideration data protection issues. And of course, compliance with data protection, if the GDPR applies, are you compliant with the GDPR? Are you compliant with POPI if it does apply?
Okay, so I am going to then cut the mergers discussion. I know that we have some questions coming in, and I am going to try and get to them. But I think we'll move on to our next topic, which is sort of the collusion topic, and that is how data can facilitate collusion. Now, I know there has been quite a lot of stuff over the last few years in the competition space that has some of this considered in the realm of conspiracy theory, and that, you know, sort of computers can't do what we think they can do. But perhaps maybe, Nats, let's set the scene with sort of how can the use of data facilitate collusion, whether theoretically or actually, as the case may be.
So the sharing of data between the competitors has always been viewed as an absolute cardinal sin of competition law. It just is a concern that it is becoming more sophisticated in the digital economy, given the developments around big data and algorithms. And so the concern that has been raised is by way of example, to the extent that there are two competitors and both of them use the same algorithm developed by the same party, such that it works in exactly the same way insofar as pricing is concerned, that can obviously result in parallel pricing between the two of them, although there's been no agreement to do so, although there has been no meeting of the minds that they would be doing that. And that's something that they're grappling with. They're also grappling with sort of artificial intelligence, learning algorithms, where the algorithms that are developed by a programmer learn in such a way that when a pricing decision comes from another competitor, it immediately reacts in a particular way and learns from doing so, which could ultimately result in tacit collusion, even though the programmer of the algorithm never anticipated that is what could have happened. And so this is something that the competition authorities are grappling with. And they're also grappling with increased transparency in the markets by virtue of the data which is put out there, and the ability by competitors to use that to monitor compliance with agreements between themselves to actually engage in price fixing. So all of this is something that they're grappling with, because one of the fundamental elements is that there must be an understanding between competitors, an intent to actually price fix. So this is something that is being considered by them, and they're considering various different types of solutions in order to deal with that.
Very interesting. Can we fix prices without knowing about it, I suppose, is the question. So, Era, from a data perspective, from a POPIA perspective, when would this be regulated under POPIA? How would POPIA be relevant in these kinds of collusion questions?
Yes, Justin, we're back to POPI 101 again. So we have to identify whether we are dealing with personal information. These algorithms, are they created based on the processing of personal information? So are you actually using personal information, or are you using anonymized or de-identified data, which doesn't relate back to a human being or a company? Now, I often find that my clients tell me that, of course, we're outside of the scope of POPI because we're using hashes. We hash our information, and then we create these wonderful algorithms, and the algorithms will tell us whether a person is going to take up credit, or whether a person is likely to repay us. Is a person going to be interested in financial products, or will a person not be interested in that at all? Are we going to send targeted marketing to a person or not? And it's always very interesting to check whether the data is really de-identified and outside the scope of POPI. Now, it's very important to recognize that in terms of POPI, information is only de-identified if it can never be resurrected again. So if you can take those hashes and you can dehash or unhash or unencrypt or use a key to decipher the information again, then what you're dealing with is not de-identification. Your data is not anonymized. At best, it's pseudonymized. So pseudonymization of data is a very useful technique to meet condition 7, to act as a security feature so that you keep that data safe. If it's compromised, hopefully the third party can't identify it. But that personal information still falls within the scope of POPI. It's not de-identified. So I always tell my clients, please watch out whether that data really cannot be resurrected, can't be re-identified. So the minute you are dealing with personal information, then all those things that I've mentioned today already quite a few times would kick in. You must comply with all the processing conditions. You have to check whether you're dealing with special personal information and so on. And just to add to make this a little bit more complicated, if you're now going to use your algorithms and you go and wash it against databases of credit bureaus, then we don't only have to worry about POPI and the Competition Act, we also have to worry about the National Credit Act and how it regulates consumer credit information. So just to note here that we must always read all the regulations together and not just try and solve a problem under one statute where we might be creating problems under others.
I think that's at the heart of what we're debating today, is how this all fits together. So just turning back to Natalia for a moment, I know the Commission has been looking at this, and there are difficulties in detection. Are they looking at any particular solutions? Has the Commission envisaged any particular things to sort of address these things?
So I think once more the Commission has recognized that there are issues and that it may be lacking in certain skill sets in order to deal with these very, very difficult issues of algorithm. And they often will bring in external service providers that can help them unpack algorithms and understand how that works. But in their view, that isn't sufficient. So what they have proposed in their paper on digital economy is to pilot a bid rigging detection program, as has been done in other areas of the world, a cartel forensics lab in order to be able to sort of identify what's going on. They also, which I thought was very interesting, are proposing to issue guidelines to establish the Commission's jurisdiction in cases of digital collusion. And so that is particularly interesting in the sort of current case law and the sort of current legislation that we have out there relating to jurisdiction. And so the most recent case where one is looking at jurisdiction is really the sort of banking foreign exchange collusion case, alleged collusion case that has been dragging on for many, many years. And so the issue there is many of those respondent banks are not in South Africa, have no turnover in South Africa. And they are arguing that on that basis, the Commission has no jurisdiction over them. And I think that's something that the Commission is considering on a forward-looking basis, because arguably there may be instances where you have a range of competitors not based in South Africa, not earning turnover, but in their mind, still engaging in potential collusion, which impacts on the South African consumer. And how do they then get jurisdiction over that? And so once more, it'll be interesting to see what comes out of the Commission's guidelines, because that is very much set out in the Competition Appeal Court's decision as regards the jurisdictional points that would need to be established in these sorts of cases. And it'll be interesting to see the extent to which the Commission's guideline aligns with the Competition Appeal Court's decision. And to the extent that it doesn't, where does that leave us?
Thank you. And I am cognizant that we only have a few minutes left. So I'm going to ask Ira, maybe just in a nutshell, for some final thoughts. From a popular perspective, what should organizations be on the lookout for?
Well, there are some hidden things that we should look out for. For example, in Section 56, when it comes to prior authorization from the regulator, if you intend to use unique identifiers, if a responsible party takes unique identifiers that it collected for a certain purpose, and it now wants to use it for a different purpose, and it wants to link it to information of another responsible party, and we often see this with creating these fancy algorithms, then you need pre-authorization from the regulator. We can't get that pre-authorization yet. We're waiting for the regulator to give us more guidance on that, so we don't know too much about that yet. Also, transfers of personal information. If you were to send any special personal information of children outside of South Africa, you are also going to need authorization from the regulator. So those are just two things to be mindful of. We always need to identify whether we're dealing with ordinary personal information, or we're dealing with special personal information. Is it personal information? And be incredibly mindful of that juristic person element. How the juristic person element is going to pan out in South Africa, we don't know yet, because we can't look at the guidance overseas. But if you use international due diligence templates and so on, please make sure that you do incorporate that juristic person element. And again, I've mentioned that already, please make sure if you're relying on your data being anonymized or de-identified, make sure it really, really is de-identified information. And just last thing, what I want to note is, if you're processing this personal information in South Africa, clearly POPI applies, but the likes of the GDPR has got extraterritorial effect. So we also need to assess whether the GDPR catches our processing of personal information, be it for creating algorithms or whatever else we want to do with data. And if you are not established in the EU, but you are monitoring the behavior of people in the EU, then you also trigger the application of the GDPR. So just be mindful. We talked a lot about POPI today, but there may also be application of foreign laws such as the GDPR that we should be mindful of.
Thank you very much. I would love to ask the rest of the team for their final thoughts, but I'm cognizant that we have literally 1 minute left on the clock. We haven't had an opportunity to take any questions, but I have noted the questions, and we will do our very best to answer them or at least to come back to you in writing. So if I could ask just the competition team, either Natalia or Jeremy, to share 30 seconds of sort of last thoughts and sort of key takeaway.
So if I may, the Commission's paper on the digital economy makes it very clear that it's grappling with difficult issues, and it's grappling with the concept of whether its legislation suffices or whether it needs to introduce new measures in order to deal with aspects of the digital economy. And so the only thing that we need to be mindful of there, and that the Commission must be mindful of, is not to stifle innovation and to stifle the amazing startups that are operating out there that may require capital and that may require input and guidance from larger firms, by inadvertently over-regulating where it's not necessary. It'll be an interesting world we're going into. Indeed.
We are off the clock, I think. Thank you, everybody, for joining us. We will get to the Q&A as soon as we can, and hopefully you learned something interesting today. Thank you for joining us.